Good afternoon. Welcome again to the 2023 Pulse Bar Ups pre-week, and I will be your host for today's session. My name is Luis Leal. Before we begin, let me give you a quick summary on what this event is all about. This is a Bar Ops 2023 pre-week, a discussion on the frequently asked topics on the 8 bar subjects, a project of Philippine Association of Law Schools and Rex Bookstore. Welcome again to our discussion theories. And if you have missed the previous discussions or lectures, these videos are available on our Facebook page, which is the PALS page, Philippine Association of Law School page, and as well as the Rex Bookstore page. So we encourage everyone to please subscribe, like, and follow so that you can be updated on the upcoming discussions. I would like also to remind everyone that this will be a 3-hour lecture. We are highly discouraging you guys from recording and reproducing these discussions and lectures for your personal gain. You can always view them every time on our lectures and discussions on our Facebook pages. So again, please like, follow, and subscribe to our Facebook page. If you have questions while the lecturer is presenting, you may comment it down below and we will entertain them at the end of the discussion. Now, to begin the discussion, let me formally introduce to you to our lecturer for today that I'm pretty sure that you know who will be our lecturer for today. So here it goes. Our lecturer for today, he is a Dean and Professor of Law in the UST Faculty of Civil Law, Professor of Law for the UP College of Law, Professorial Chair Holder, a public speaker and lecturer, bar reviewer, author, successful law practitioner and experienced administrator, founder and managing partner of Divina Law. He has been a chairman and president of Philippine Association of Law Schools, co-general counsel and chairman on the Legal Education and Bar Admission of the Integrated Bar of the Philippines, resource person for the Senate of the Philippines Committee on Amendments, 6th Congress on proposed amendments to the Corporation Code. He has also guest in various TV and radio programs on a whole range of legal issues on matters of public interest. May I present our lecturer today for commercial law, Dean Nilo Divina.
Thank you, Louis. Good afternoon,
Thank you.
everyone.
Good afternoon.
All right, please join me in prayer. Dear God, source of all my being and countless blessings, through you, in you, and with you, all things are possible beyond my imagining. As I embark on this journey to hurdle the bar and approximate my goal towards becoming a lawyer, I humbly beg you to send me your divine grace. Answer the questions unaided by your wisdom. Memory to help recall things I've learned yet to learn. Faith, secure in the truth that you are with me all the days of my life. Hope, you are the anchor of all I am and hope to be. Rectitude of intention, that I may discern and glorify your will. I pray, Lord, that you grant my desire to exalt and praise you through the results of my lips. Help me to do my best to override my preparations with your grace. Calm me, strengthen me, and embrace me dearly, thus though with limitations. I offer this bar as a way to seek your kingdom, for as it is written, first the kingdom of God, and everything will be added unto you. Persevere, work diligently, pray unceasingly, rest in your promises, and have all on your unfailing love. In the mighty name of your Son, Jesus Christ, and through the intercession of our Mother, Mary, in favor of being born, I pray. Amen. Our Father who art in heaven, hallowed be thy name. Kingdom come, thy will be done. Give us daily our bread. Forgive us our trespasses. Forgive us our trespasses. Jesus, lead us not in temptation, but deliver us from evil. Amen. Hail Mary, full of grace, the Lord is with you. Blessed are you among women. Jesus. Holy Mary, Mother of God, pray for us sinners now. Amen. Glory be to the Father, the Son, and the Holy Spirit, as it was in the beginning, so now and ever shall be. All right, so this is a short lecture on frequently asked bar questions in commercial law, of course, sponsored by Rex Bookstore in collaboration with the Philippine Association of Law Schools. Okay, let's start with insurance first. Insurance regarding characteristics of insurance contract is very important. Think twice or thrice asked in the bar, the case of Cha versus Court of Appeals regarding a stipulation in a lease agreement that the lessee shall not obtain or procure fire insurance on his properties within or located in the lease premises without the consent of the lessor. And in case the lessee does procure or obtain the property insurance without the consent of the lessor, then the insurance proceeds are automatically payable to the lessor. And then let's say the property was destroyed by fire, can the lessor obtain the insurance proceeds? And of course, the answer obviously is no, right? For two reasons. The first reason is that the lessor does not have insurable interest over the property subject of the contract of insurance. The goods, the properties that were covered by the fire insurance are owned by the lessee, not owned by the lessor. So lessor has no connection with the property that is owned by the lessee to give him insurable interest there too. And then second, every time the insurer enters the contract of insurance with the insured, it takes into account the qualifications of the insured. So the insurer provided insurance coverage to the lessee because of his qualifications and circumstances, not the qualification or circumstances of the lessor. Next. Or there's also a favorite question in the bar regarding the liability of the insurer in the event that the vessel is not seaworthy. So what makes the vessel unseaworthy? It is unseaworthy, as you know, if it is not properly equipped and adequately manned to carry out the voyage. So it goes into the adequacy of the equipment and competence, sufficiency of the personnel to carry out the voyage, right? So if the damage to the vessel or the goods is due to unseaworthiness, then the insurer is not liable. Why is that? Because in any contract of marine insurance, there is an implied warranty of seaworthiness. That warranty is assumed, of course, by the insured. So it warrants, as the case may be, to the insurer that the vessel is seaworthy. Next. Now, of course, there is an exception. Also asked a favorite question likewise in the bar. Is there a situation where the insurer may be held liable despite the fact that the losses or damage to the subject of insurance are due to perils of the sea and perils of the ship? Meaning, even though the damage or loss was due to unseaworthiness. Yes, in case of an all-risk marine insurance policy. Because the all-risk marine insurance policy covers any all kinds of losses or damages, whether due to unseaworthiness, due to perils of the ship, or perils of the sea. The only exception, as you know, in case of the all-risk marine insurance policy, will be a risk accepted by the policy or the acts of the insured itself. Meaning, despite an all-risk marine insurance policy, the insured cannot recover if the loss or damage was due to his own acts. Next. All right. Of course, obviously, for life insurance, this is the very favorite topic. We all know that a person may procure insurance on his own life and designate anyone as his beneficiary, right? And the only disqualification, you know, the only prohibition is that the insured cannot take insurance on the life of a person disqualified to receive donation under 739 of the Civil Code. Okay. So the favorite core part of that one of 739 is common law spouse or concubine. So the insured may take insurance on the life of anyone. Exception, his concubine or common law spouse. All right. Now what happens if the insured procures insurance on his own life and name his common law spouse as beneficiary. Who will get the proceeds of the insurance? Will it go to the surviving spouse of the insured, I mean the lawful spouse? Will it go to the heirs of the insured, or will it go to the estate of the insured? The correct answer, as you know, is it will go to the estate of the insured. It's not correct to say that the proceeds are payable to the heirs of the insured, but it's payable to the estate of the insured, because the estate includes the heirs. But it's more appropriate to call it to say or to answer that the proceeds will go to the estate of the insured. And a possible variation, also a favorite question in the bar: what happens in case of joint designation of beneficiaries? Let's say one unlawfully named and the others lawfully named or designated. A common law spouse and the children of the insured with the common law spouse. The case of Maramag versus Maramag, as twice or thrice in the bar. So in that case, you will get the proceeds of the insurance policy. Will one half go to the lawfully named beneficiary, by beneficiaries, meaning the common law children, because there is no prohibition, as you know, in naming common law children as beneficiaries. And the other half will go to the estate of the insured. But the answer is the entire proceeds shall go to the lawfully named beneficiaries, meaning the children that the issued has with or had with a common law spouse. So the share of the unlawfully named beneficiary, that is a common law spouse, shall be forfeited in favor of the other lawfully named beneficiaries, in this case, the children with the common law spouse. Next. Also, a favorite question in the bar regarding suicide. So you know that in this case, let's take a look. X, January 30, 2009, or 2 years before reaching the age of 65, meaning 63, that is, insured his life for 20 million. For reasons unknown to his family, he took his own life for 2 days. 2 days after his 65th birthday. So meaning 2 years and 2 days had lapsed from issuance of the policy when he committed suicide. So which statement is most accurate in this case? The insurer is provided the answer will be liable. The insurer will not be liable only if the insured committed suicide within 2 years from issuance of the policy, but will be liable if the insured committed suicide, of course, after 2 years from issuance of the policy. The only exception, as you know, in case of insanity, which is compensable regardless of the date of the commission of the suicide. Next. Also, a favorite question in the bar, as you know, the so-called I think this is 6 or 7 times asked in the bar. The concept of incontestability clause and the effects of the setting in of this clause on the rights of the beneficiaries to the proceeds of the policy, or the rights of the insurer to rescind the policy, as the case may be. So first, what is incontestability clause? You all know this is a clause applicable only to a life insurance payable upon the death of the insured, right? And then 2 years had lapsed from issuance of the policy or last reinstatement. If these two concur, meaning you have a life insurance payable on the death of the insured, and the 2 years had lapsed from issuance of the policy or last reinstatement, then the insurer is precluded from rescinding the policy on account of concealment or misrepresentation. So no matter how patent, how obvious, and how gross the concealment or misrepresentation may have been, the insurer is precluded from rescinding the policy on these grounds. So that is simply foreclosed or ended after the lapse of the 2 years, or the so-called setting in of the incontestability clause. All right. Now, so this is another variation as well asked in the 2021 bar examination. So what about if the insured dies within 2 years? Insured dies within 2 years. Does the clause set in? Right, just to clarify. So the clause as we understood it before the case of Aban versus Manila Bankers and Sun Life versus Sibia is that 2 years must lapse from issuance of the policy or last reinstatement, right? Now, in Sun Life versus Sibia, And when the bankers versus ban, the Supreme Court said if the insured dies within 2 years, right, or 2 years had lapsed from issuance of the policy, then the insurer must make good on the policy despite the concealment or misrepresentation. That somehow conveys the impression that there are now two kinds of incontestability clause. The first, if 2 years had lapsed from issuance of the policy or last statement, and second, if the insured dies within 2 years. All right? Now, how will you answer it in case it will be asked again in the bar? That is, if the insured dies within 2 years, is the insurer liable, or has the clause set in, or is the insurer not precluded from rescinding on account of concealment or misrepresentation? So as we suggested in that bar examination, so the pronouncement in Sun Life versus Sibia and the ban versus Manila versus ban, that the clause sets in within, if the insured dies within 2 years, is only an obiter dictum. Only an obiter dictum. So the correct interpretation of the incontestability clause is the insured died within, after 2 years rather, from issuance of the policy or last, so I mean, 2 years had lapsed rather, from issuance of the policy or last statement. The death of the insured is immaterial, right? What is material is 2 years had lapsed from issuance of the policy or last statement. If that is the case, then the insurer must make good on the policy despite concealment or misrepresentation. Next. Okay. Also, incontestability clause. Next. Okay. Covered. All right, on compulsory motor vehicle liability insurance, the most favorite topic or source of question is, of course, the no fault indemnity clause. And I think this particular set of facts was asked 3 or 4 times in the bar. Let's say X is a passenger of a jeepney driven by Y, so that jeepney was hit from behind by a passenger, another vehicle driven by Z, let's say owned by A. All right, so the injured party, the injured passenger, or the injured party, passenger of vehicle X, vehicle X hit from behind by another vehicle operated by another person, driven by another person likewise, against whom may the injured party, the passenger that is, file a claim under no fault indemnity clause. Can he file it against the insurer of the offending vehicle, or the insurer of the vehicle where he's an occupant, mounting or dismounting from, or from the insurer of the operator of the vehicle? So if the claim is on the no fault indemnity clause, as you know, it will be filed, will have to be filed against the insurer of the vehicle where he was a passenger or mounting or dismounting from. Next. Another favorite question in the bar on insurance regarding life and property insurance. When is insurable interest required to be present? As you all know, for property insurance, it must be present at the time of the perfection of the contract and the time of the loss, whereas for life insurance, it's enough that it was present at the time of the perfection of the contract and need not be present at the time of the loss. There are so many examples and so many bar exam questions, but let's just focus on one. So to illustrate the point that in property insurance, it is important that the insured must have issuable interest when the contract took effect and the time of the loss. Okay, basic example from which you can draw. Principle you can apply to the other questions, even though it can be permutation of so many questions. Let's say mortgagor procured fire insurance on the mortgage property, right? And then mortgagee likewise procured fire insurance on the same mortgage property to the extent of the amount of the mortgage debt. So you all know that the mortgagor has issuable interest in the property because of ownership, The mortgagee has issuable interest by reason of the debt or the loan he granted to the mortgagor, right? So let's say the mortgagor failed to pay the obligation. As a consequence, the mortgagee foreclosed the mortgage, right? Now, during the redemption period, the property was just gutted by fire. Can the mortgagor and the mortgagee recover on the respective fire insurance policies? Of course, the answer, the mortgagee obviously may recover, right, on the separate fire insurance that he procures. What about the mortgagor? Can the mortgagee recover on his fire insurance? Yes, right? Because he had issuable interest at the time of the perfection of the contract and at the time of the loss. Now, what about if the fire destroyed the mortgage property at the after expiration of the redemption period? What happens now? Well, in that case, the mortgagor can no longer recover because he has lost issuable interest on the property at the time of the loss. And then this one, likewise, a favorite topic in relation to this discussion. So mortgagor again obtain a loan from the mortgagee, and then thereafter obtain a fire insurance on the mortgage property. All right. The loan was not paid, so the mortgagee foreclosed the mortgage. While the period of redemption is pending, the mortgagee procured fire insurance on the mortgage property. Right. Now, again, during the pendency of the redemption period, the mortgagor, to raise the money to pay the mortgagee, assigned the insurance policy to a creditor. Right. And thereafter, the property is destroyed by fire. Who can recover? The mortgagor, the mortgagee, or mortgagee and assignee, or mortgagee only? The mortgagee for sure may recover because he procured the fire insurance for his own interest, non-payment of the mortgage debt. What about the mortgagor? The mortgagor has no right to recover on the fire insurance he procured because he has no more issuable interest at the time of the loss, having assigned the policy in favor of the creditor, right? What about the assignee of the insurance policy? Can he or it recover on the insurance policy assigned? The answer is no, because he had no issuable interest at the time of perfection of the contract. He may have issuable interest at the time of the loss, but none at the time the contract was perfected. And both must concur for property insurance. All right. Now, for life insurance, of course, combination of property and life, also a favorite question. Remember this one? Let's say a CEO was hired by a multinational company, and one of the privileges granted to the CEO is housing accommodation. So the company purchased a condo, a luxurious condo for the CEO president. So the company procured life insurance on the insurance on the life of the president and made the firm or the company the beneficiary. At the same time, the company procured fire insurance on the condo unit where the president is residing. Unfortunately, there was disagreement between the company and the president, and the company terminated the employment of the president. After expiration, after termination of the employment, the president purchased the condo, right? Purchased the condo. And then 1 week after buying the condo, that property, the condo unit, was destroyed by fire. Right? So there are two insurance policies here: life insurance and property insurance. Can the employer recover on the life insurance, even though the president, who is of course the insured, is no longer connected with the company? Yes, because for issuable interest on life, it is enough that there is issuable interest at the time of the perfection of the contract and not at the time of the loss. What about for the property insurance? The company cannot recover because at the time of the loss, it was no longer the owner, right, of the property. Next. Okay, for insurable interest on life, as you know, a person can take insurance on the life of another as long as insurable interest on the life of the person he's insuring. Okay. And he has insurable interest, among others, in the life of the person insuring if he depends upon that person for location and support, right? So it can be partly location and support, right? As long as he relies on the person for location or support, either or both, then he can take insurance on the life of that person. So in case there be a bar exam question, may tinatawag na pampagulo, no? O yung mga red herring. As long as the facts will show that the insured relies on the person he's insuring for education or support, then he has issuable interest obviously in the life of that person. When the person dies, the beneficiary can recover. Ano sinasabi ko pampagulo dito? Yung pampagulo dito, Carlo and Bianca met, dated, fell in love, and married each other. Yun pala, yung babae ay transgender. Meron bang kinalaman? It doesn't have any bearing on the question, given that there is a sentence here that says he depended on Bianca, the transgender, both emotionally and financially. That's all that matters, right? For insurable interest. The issue of being transgender is completely material or red herring, pampagulo. So yes, the insured can recover because he relies on Bianca, the transgender, for support. Next. Okay, this one, of course, a person cannot insure, a general creditor cannot insure the property of the debtor. Why is that so? Because he has, well, it's only an inchoate, it's not an existing interest, not even an inchoate interest. It's a mere expectancy. When will a creditor acquire insurable interest on the property of the debtor? Only after levy, right? Only after levy. So the levied property may be subject of insurance, because if the debtor does not redeem that levied property, then the creditor becomes the absolute owner of the same. Next. All right, also a favorite question, the bar regard on insurance designation of beneficiary. So you all know that it can be revocable or irrevocable, right? And if it is silent, it's deemed to be revocable. And what does revocable designation beneficiary mean? It means that the insured may remove or change the beneficiary, may add a beneficiary, may subtract a beneficiary, may remove, right, exclude a beneficiary if there are two or more, right? And the beneficiary has no right to complain. But if it is irrevocable, then the insured cannot do anything that will impair the interest of the irrevocable named beneficiary. He cannot add, remove, or exclude, or even take rather the cash surrender value of the insurance policy without the consent of the beneficiary. Next. 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 All right. Also, a favorite topic or question, the bar insurance, and this is very relevant given that Justice Mon Hernando wrote a decision on other insurance. So, if an insurance policy prohibits, by the way, 2011 is the same year that Justice Hernando was a bar examiner. So this, and then he wrote the case. So he wrote the decision. I'm sorry, on this topic, the case of Multiverse versus Bellas. What happens here? If the insurance policy prohibits additional insurance, and then the insurer procures an insurance without disclosing the same to the insurer, then a violation of the by the insured avoids the policy. If there is no other insurance clause, so other insurance clause simply means, in case it gets to be asked in an objective way, other insurance clause means or obligates the insured to notify the insurer of an existing insurance on the mortgage the property or subsequent insurance that he may obtain or procure on the same property subject of insurance. If there is other insurance clause and the insurer does not make that disclosure to the insurer, then the policy is avoided. If there is no other insurance clause, as you know, the insured may take as many insurance as he wants. That is double insurance. That's allowed, as long as there is no prohibition against it. What is not allowed is over recovery. Next. Now, on double insurance, favorite question, of course, mortgage. This was 4 times asked in the bar. If the mortgage and mortgagee procure fire insurance on the same mortgage property, is there double insurance? Obviously, there is none. With double insurance is what happens if one person, meaning one insured, procures 2 or more insurance from 2 or more insurers on the same subject matter, interest, and risk. So, mortgage or mortgagee, there are 2 insured. So, rather than then, there is no double insurance, right? And of course, they have different issuable interest. The issuable interest of the insured is based on ownership. The issuable interest of the mortgagee based on the amount of loan granted to the mortgagor. Next. Next. So you know that double insurance only applies to property. Does it apply to life? Next. Okay. We have, okay. Also, kindly just concerned about the time. No? So we have many more to go. Okay. This was asked 3 times in the bar about mortgagor and mortgagee procuring separate fire insurance policy on the mortgage property. Now, for the fire insurance procured by the mortgagor, he made the proceeds payable to the mortgagee. All right. So the mortgagor set the property on fire. So the question now is, can the mortgagee recover on the insurance policy? The answer is the mortgagee cannot recover on the fire insurance policy procured by the mortgagor. Because, as you know, if the mortgage procures insurance on the property, makes the loss payable to the mortgagee, he remains to be a party to the contract of insurance. Any act on his part that may impair the insurance affects the mortgagee. So the act of setting the property on fire is an act imputable, attributable to the mortgagor, and as a consequence, mortgagee cannot recover on that insurance procured by the mortgagor. But the mortgagee, of course, can recover on the separate fire insurance that he procured. Next. 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 On perfection of insurance, twice asked in the bar, twice or twice, about 3 times. I'm sorry. Anyway, but for sure more than once. Regarding the cognition theory, right? That is, the insurance becomes effective upon knowledge by the insurer of the acceptance of the insurer, right? Not upon manifestation of the acceptance by the insurer, but knowledge by the insured that the insurer accepted the proposal offer for insurance. So therefore, if the loss occurs after perfection of the after acceptance by the insurer, but pending knowledge by the insured of the acceptance of the insurer is not liable, right? That's the cognition theory. And also, a favorite question, the bar regarding issuance of PDC, issuance of check to cover for premium. So just keep this basic principle, very basic principle in mind. If the loss occurs during the credit extension period, then the insured may recover. Simple as that. If there is no credit extension granted to the insured, right? And then the loss occurs without premium payment, the insured obviously cannot recover. But if he issues a check pending deposit of the check or pending clearance of the check, the property destroyed by fire, the insured may recover because the issuance of the check, acceptance by the insurer, is basically a grant of credit on the part of the insured. Now, what if the check bounces? The check bounces. If the check bounces, then the insured obviously did not pay the premium. In which case, the cash and carry rule applies. No right to recover in the policy. The exception is if he issues a check that bounced, but likewise issue the promissory note payable to the insurer. So despite the dishonor of the check, given the promissory note, and the loss occurs during the period of the promissory note, the Supreme Court said the insured may recover. Next. 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 All right. On rescission of insurance contract, favorite question in the bar, the effect of concealment. Now, you know that the facts concealed need not be the cause of the loss. Right? The facts concealed need not be the cause of the loss. So the insured did not disclose he had a mongoloid child. He died because of food poisoning. The beneficiaries can recover, right? Or the insured did not disclose that he was suffering from this ailment. He died because of plane crash. The beneficiaries cannot recover, right? Why? Even though the facts concealed were not the proximate cause of the loss, the non-disclosure of that information, having a mongoloid child or having this ailment, is material because it could have prompted more inquiries from the insurer. It could have changed his estimates of the risk, and it could have changed his analysis of the disadvantages rather the kind of insurance, or it could have charged higher amount of premium. The test of materiality, as you all know, is the reasonable and probable influence of the facts concealed to the insurer in making inquiries and forming the estimates of the risk. The question is, had he known about this information or facts, would they have charged a higher premium? If the answer is yes, then that information or those facts are material and non-disclosure thereto by the insured amounts to concealment. That's all right. Now, this one was asked twice in the bar regarding the transfer of the property from one building to another, right? Without communicating or making it known to the insurer. So obviously the insurer is not liable for what reasons? The first reason is that information, the transfer of the property from one building to another, is material information that should have been disclosed to the insurer. So there was concealment in this case. And the second, alteration, right, in the use or condition of a thing insured made without the consent of the insurer that increase the risk insured entitles the insurer to rescind the policy. Next. Next. All right. Also, favorite question on subrogation. 2011 is, as I told you, the same year that Justice Mon Hernando was bar examiner. So if you have a copy, well, not that I'm advertising, 2011. Take a look at 2011 bar examination. Because he was, as I said, the bar examiner. And what is the effect of subrogation? There is basically equitable assignment of the rights of the insured in favor of the insurer. And because of equitable assignment of rights or remedies that the insured has in favor of the insurer, they does not require the consent of the insured, consent of a third party wrongdoer. So the moment the insurer pays the insured, he steps into the shoes of the insured, acquires the rights and remedies of the insured, and can run after or proceed against the one who caused harm or injury to the insured or violated the contract with or without the consent of the insured or the third party wrongdoer. Next. Okay, let's move on to transportation. On transportation, of course, favorite question, obviously. Um, First, let's go by definition of common carrier. Any person engaged in the business of carrying or transporting passengers or goods or both by land, air, water for compensation, offering the services to the public. Right? Now, the part that is often asked is, should the transportation activity be the principal business of the carrier? If you consider the common carrier, you all know it's not, right? It's not. So it is enough that it is part of his business activity, not necessarily the principal activity, but part of his business activity that he holds out to the public as his own business. If that is so, he is a common carrier. This one, the case of Sun Holidays versus Sun Holidays, the Sun Holiday case, and then you have the case of Pereña versus Nicolas. All right, then of course you have the case involving caution broker, right? So why is it that all of these cases, the carrier considered a common carrier? Sun Holiday versus Cruise, what happened? So A owns a beach resort in let's say Palawan. So that is principal business, operates, runs, manages a beach resort. But the guests are ferried from the port to the resort using a bangka or a boat, motorized boat, owned likewise by Wanderer Cruise, right? Let's say he has 3 boats. So those 3 boats are limited to the guests of the hotel. Pick them up from the airport, then bring them to the resort, and then back to the city proper, or back to the airport rather, after their the end of the stay in the resort. So let's say nag-capsize yung isang bangka while being operated by the captain, who is not even employed, let's say, by the port or the resort owner. Is the resort owner considered common carrier? And somebody said yes, right? Even though he is limited to the guests of the resort. Why? Because the element that says offering transport services to the public doesn't mean offering transport services to general public. It's enough that they are offered to another segment of the public, but indiscriminately. All right? Another case, yung Perea versus Nicolas, you remember? Informal school bus operator. School bus operator. Yung sinusundo ng driver limited sa mga residents ng isang subdivision. Yung mga anak ng mga ng kliyente na estudyante ng Don Bosco, ihahatid ng school bus operator sa school and then back to the subdivision. All right, is informal school bus operator a common carrier, even though limited in clientele? And the Supreme Court said yes, right? Because the owner offers services to the public. It doesn't mean the general public, but narrow segment of the public will suffice. And then, of course, the last one, very important because of so many cases, a custom broker. A custom broker doesn't own a vehicle. A custom broker hires a trucking company, right? The custom broker simply pays for the custom duties, signs import and declaration form, and performs any and all acts required or necessary to take the shipment from the customs so that they can be delivered to the consignee. So if the goods are picked up or obtained by the custom broker, it doesn't end there. They have to be delivered to the consignee, right? But the custom broker may not have a vehicle, or most cases doesn't have a vehicle. It hires a trucking company, right? A trucking company will be the one to deliver the goods to the consignee. But the custom broker is a common carrier, even though the principal business is not that of transportation. Principal business is one of payment of import duties, right? And getting paid for getting goods out of the custom. Why? Because transportation is an essential part of its activity that he owns out to the public as his own business activity. And for this reason, considered a common carrier. ownership of vehicle is not an element to consider the common carrier. What is important is he holds out to the public that he is engaged in this transport business for compensation. Next. All right. Are common carriers liable for injuries? Justice Hernando, by the way, examined 2011, 2016, 2009. Three times, no? So he's an expert in commercial law. So 2009, 11, 16. So one of the questions he asked, the defense that may be raised by common carrier. The defense, of course, is extraordinary diligence, right? What about the defense that the common carrier exercise due diligence in selection, supervision of employees? Is that tenable? It's not. That is appropriate for tort or quasi-delict, but not for breach of contract of carriage. There's only one defense. In case of breach of contract of carriage, extraordinary diligence in the vigilance of the goods and ensuring the safety of the passengers. Ordinary diligence, of course, will not suffice. Next. All right, this is also a favorite question, about I think 6 or 7 times asked, no? Different kinds of passengers, different kinds. Stowaway, all right? A mistress, a pickpocket, a passenger with discounted fare, and a passenger carried out or carried gratuitously. So 5. Stowaway, pickpocket, mistress. And then passenger with discounted fare, and the last one, passenger carried gratuitously, right? So in case of injury to all of these 5 passengers as a result of the negligent operation of the vehicle by the driver assigned or hired by the operator, can all of them sue for breach of contract of carriage the operator of the vehicle? The answer obviously is no for the stowaway, no for the pickpocket, no for the mistress. Because there's no contractual relation, there's no contract of carriage with them. It was not the intention of the carrier to have contract of carriage with them, right? What about the one carried gratuitously? There is a contract of carriage, despite the gratuitous nature of the contract. What about the one carried or given discounted fare? As you know, there's likewise a contract of carriage. The one with the discounted fare does not change the obligation or the extent of diligence required of the common carrier. It remains to be extraordinary. The one carried gratuitously, of course, that's different. The law says if the passenger carried gratuitously, a stipulation exempting the carrier from negligence, stipulation exempting the carrier from simple negligence is valid, right? As long as it's not due to willful acts of gross negligence. So meaning it is converted into it's akin to a private carrier, it passes carried gratuitously. A stipulation basically limiting the liability for simple negligence is valid. So in effect, so extraordinary diligence is reduced to ordinary diligence in effect. All right, next question. Do those 3 have any cause of action against the operator of the vehicle and the driver of the vehicle? They cannot sue the operator for breach of contract of carriage, right? But they can sue for quasi-delict or tort. If there was negligence or lack of diligence in the selection provision of employees, they can likewise sue the driver also for quasi-delict, and they can likewise sue criminally the driver because of reckless imprudence. But they can never sue for breach of contract of carriage. Defense is available to the operator of the vehicle and the driver of the vehicle. If the suit or cause of action is based on breach of contract of carriage, or the defense of the operator, no contract of carriage, that is with respect to the mistress, stowaway, and pickpocket. All right. We have discussed the one carried gratuitously and the one carried with discounted fare. If the suit or cause of action is tort or quasi-delict by those 3 non-passengers, stowaway, pickpocket, and mistress, the defense is due diligence in selection supervision of the employees. Next. Okay, same question, same principles. Same, right? Next. All right. So another question you type just Senado 2011 bar. So when does obligation of the common carrier commence? It commences when the goods are placed constructively with the common carrier. So it doesn't mean it starts only during actual transport, right? The moment the goods are turned over to the assistant, attendant, staff, employee of the common carrier, even before boarding, then the obligation already starts. Therefore, in case of loss of the goods in the possession of the common carrier before actual boarding, then the carrier is already liable. You all know that in case of loss or damage to goods, the common carrier is presumed to be at fault or negligent unless it can show exercise of extraordinary diligence. Next. Another 2011 bar examination. So what is the basis why common care is presumed to be liable or negligent and liable in case of loss or damage to goods or injury or death to passenger? Is it because of respondeat superior? No, it's because there is an implied duty on the part of the carrier to transport the passenger safely. Next. Next. All right. Okay. Ano also favorite topic or question the bar regarding liability of the carrier? Liability of the carrier for acts of the employees, acts of agents of the common carrier, acts of persons hired by the common carrier, and acts of passengers or third party. So here we have to make a clear distinction. So if the death or injury is caused by the employees of the common carrier, then the common carrier is liable. In fact, it's no longer presumed the common carrier is liable, even though the employees may have acted beyond the scope of their authority, or the employees may have violated the instruction of the common carrier. Let's say common carrier says or instructs all of the employees, the conductor, driver, don't bring any dangerous dangerous weapon with you, and then the conductor brought a knife and then stabbed a passenger. Is the carrier liable, despite the instruction given to the conductor not to bring any dangerous weapon? The conductor obviously violated the instruction, and yet the law makes the carrier liable for the acts of its employees. So in effective, the Supreme Court said the insurer or the common carrier insurer of the safety of passengers for acts of its own employees. What about acts of not employees, but acts of agents or third party hired, employed, contracted by the common carrier? The case of MRT versus Navidad. Remember that case? That was asked twice in the bar. So yung passenger purchased a token or a ticket, no? And while waiting for the coach or train to arrive, he was pushed from behind by the security guard hired by the agency with which the common carrier contracted with. The security guard was not hired by the common carrier, not hired by MRT, but hired by an agency with which MRT had contracted with. And Supreme Court said, well, the common carrier is liable, right, for the acts of the agents, I mean, the act of the security guard. What about if the death or injury caused by a third party, a co-passenger, a bystander? Co-passenger, the case of Batung versus for the transport. One of the passengers shot, right, a co-passenger. He was able to carry his gun surreptitiously without not being seen or detected by the conductor of the transportation company. So sabi ng Supreme Court, you remember, for acts of passengers or third party, the common carrier is not the insurer of the safety of the passenger, because it can be exempted from liability by showing due diligence to prevent or stop the act or the incident. Now, what about action of third party? In the case of Pilapil versus CA, remember, also asked times in the bar, binato yung passenger ng bystander. Liable ba yung common carrier? And Supreme Court said, no liability, right? Because extraordinary diligence is not the norm, but simply one of ordinary diligence. So it was an accident. It was beyond the control of the common carrier, and it exercised due diligence under these circumstances, and as such, not liable. There was a twist to it. In other bar exam question, there were previous incidents of stone throwing in the area. But despite incidents of stone throwing, the carrier did not advise the passengers accordingly. Now, that case, I mean, for that particular case, rather, the common carrier is no longer exempt from liability, but now liable. It should have given appropriate advice and installed or adopted preventive measures to prevent the happening of the incident. So there was no longer due diligence on his part. Lack of due diligence, in fact, by not adopting the appropriate measures to prevent or stop those incidents of stone throwing in the area. Next. Well, threefold. I don't think this part of the bar. Okay, this one. Next slide, Sarah. Well, your syllabus does not make specific mention of different kinds of charter party agreement, but it has reference to obligations, rights and obligations of parties to a contract of carriage. So we may have to include, therefore, in our discussion of frequently asked questions, the concept of bareboat or demise charter, because the favorite question in the bar on transport. You all know there are three different kinds of charter party arrangements. You have bareboat or demise charter, you have time charter, and you have voyage charter. So just take a look at the facts of the case. If it is a voyage charter, meaning the vessel is chartered for a particular voyage, or a time charter, the vessel is chartered for a particular period of time, like 30 days or 90 days, as the case may be, then the ship owner retains the status of a common carrier. What does it mean? It means that in case of loss or damage to goods or death or injury to passengers, the presumption is the ship owner, being a common carrier, is at fault. And to relieve itself of liability, it must establish exercise of extraordinary diligence. Okay, so a ship owner retains the status of a common carrier, and the presumption of fault and negligence therefore applies against it. What about in case of bareboat or demise charter? So the ship owner becomes a mere lessor, right? Mere lessor, not a common carrier. So that's why in case of loss or damage to goods, the ship owner as a mere lessor is not liable. So let's say ship owner chartered the vessel to ship owner A, chartered the vessel to X, and then X loaded goods into that charter vessel, set sail, and then in the course of the voyage, the vessel capsized. Is the ship owner liable? No, because it's no longer a common carrier, a mere lessor. So the loss should be borne by the charterer. Or another example, the charterer entered into contracts with the shippers or cargo owners. Siya yung nakipagkontrata, hindi ship owner, yung charter nakipagkontrata sa mga shippers at cargo owners who loaded their goods into the charter vessel. And then, okay, voyage ensued, the vessel capsized, resulting in loss or damage to the goods loaded into the vessel. Can the owners of the cargoes, meaning the shippers, run after the ship owner, they cannot. They can only run after the charterer, right? But not against the ship owner, because in that kind of arrangement, the ship owner becomes a mere lessor, right? Now, what makes it a bareboat or demise charter? What makes it a time or a voyage charter agreement? So be careful with the facts of the case. If what is given to the charterer is both possession of the vessel and the authority, the power to navigate the vessel, so control over, meaning possession and control over the vessel, it means it is converted into a bareboat or demise charter. So the responsibility lies with the charterer, no longer with the ship owner. If what is given is only possession of the vessel, but control is retained by the ship owner, meaning the captain, the crew remain to be employed by the ship owner, and the ship owner to this captain, crew member, control the navigation, it remains to be, or the ship owner remains to be, a common carrier. And the presumption of loss of good, damage to goods, presumption of negligence rather, in case of loss or damage to goods applies. Next. Okay, we can, all right. Now, regarding Public Service Act. Second. Okay, we all, well, it's not part of the frequently asked bar exam question lecture, obviously, because it's a new law, the Public Utility Act, the Public Service Act is amended. But this was asked twice in the bar. The case of Gamboa versus Tebes, and then Roy, well, Gamboa versus Tebes, twice, no? But no case, no question yet on Roy versus Herbosa. And I predict it may be asked this year, no? Because it's been more than 4 years in the case for the Cyber Supreme Court and Bank. Roy versus Herbosa clarified, or you may say, set aside, no? Gamboa versus Tebes. First, let's refresh our memory. In Gamboa versus Tebes, the Supreme Court said the term capital means voting shares, right? Voting shares. So non-voting shares is not part of capital. In what context do we understand this? Under the Constitution, a public utility or the capital of a public utility shall be at least 60% owned by Filipinos. All right? If the Filipinos own less than 60% of the capital, then that public utility is not compliant with the Constitution. Okay. And capital means voting shares. So let's say there are 200,000 outstanding shares, 100,000 common, 100,000 preferred shares. The pref shares are non-voting, right? And then of the pref shares, let's say 100,000 owned by Filipinos, and then common shares, 20,000 owned by Filipinos, 8,000 owned by foreigners. So 120 over 200 owned by Filipinos, except that 100,000 of the 120 are non-voting. Is it compliant with the Constitution? The answer is, in Gamboa versus Tebes, no. Because the Filipinos may own 60% of the outstanding capital stock, but not 60% of the voting shares, right? And then in a motion for recall, the Supreme Court also said that if the corporation is a mixture of shares, common, preferred, or any kind of preferred shares, the 60-40 must be mirrored for each type of shares, right? Each type of shares. Not anymore. Not anymore. So the rule is now simply, as long as the Filipinos own at least 60% of the voting shares and 60% of the standing capital stock, no, then is compliant with the Constitution for all industries and activities where the law requires 6% ownership of the capital by Filipinos. So it's no longer 60-40 for every type of shares, but only 60 for the voting shares and outstanding capital stock. So it need not be 60-40 for every type of shares. It should not be 60% of the voting and of the standing capital stock are owned by Filipinos. Next. Next. Okay, let's move on to corporation. 1 second. This question becomes relevant because of the concept of one-person corporation under revised corporation code. So what are the advantages or disadvantages of a single proprietorship or simply setting up a branch of an existing corporation for an expansion business? Okay. Let's say you own a business, you want to expand. So what are the options available to you? Sole proprietorship or just a branch of existing corporate business or corporation running the business. Advantages of a sole proprietorship, of course, well, simple, it's easy to operate, and you're in complete control of your business. But the disadvantage is that all of the liabilities of the business are the liabilities of the proprietor, and the assets of the proprietor may be made to answer for the obligation of the business because the business and the person running or own the business, the proprietor, are one the same entity. So the single proprietorship has no separate legal personality, as you know, from the proprietor of the business. All right. What about a branch? Well, branch is an extension of the corporation that has no separate legal personality, right? And the advantage is that the subscriber limited to subscription to the corporation, but a subscriber is also director or an officer, and in case of mismanagement, in case of bad faith or gross negligence, that director officer may be made to answer even beyond his contribution to the corporation, right? That we know. What about a one-person corporation? Well, a one-person corporation, of course, different from a single proprietorship. The difference basically is that a one-person corporation has separate legal personality from the sole stockholder and vice versa. And therefore, the liability of the sole stockholder does not go beyond his contribution or subscription to the one-person corporation. And the assets of the sole stockholder cannot be made to answer for the obligation of the corporation unless there is a ground to pierce the veil of corporate fiction. Next. All right, this becomes important. You all know that this type of corporation that allowed to issue no par value shares, we have to add pre-need company, right, under the revised corporation code. Next. Okay, let's skip this part. Next. Okay, this one is very important also about the concept or definition of foreign corporation, domestic corporation, and Philippine national. So you have a corporation organized in Malaysia, a branch in the Philippines, composed entirely of Filipinos. Do you consider ABC a Philippine, a domestic or foreign corporation? The answer, of course, is ABC is a foreign corporation, despite the fact it's composed of Filipinos, right? Because it's organized under the laws of Malaysia. But if the question is it a Philippine national? The answer is, it is a Philippine national. A foreign corporation composed entirely of Filipinos is a Philippine national as long as it is registered as doing business in the Philippines. Next. Next. I think we have covered this. All right. The grandfather rule. I didn't discuss this in the listener. I don't think so. All right. this is ripe for the taking. The application of the grandfather rule and the control test. Well, this one was asked in the bar. You all know what control test is, right? Control test is a mode of determining nationality of corporations engaged in nationalized activity under the Constitution or special law by ascertaining the nationality of the controlling stockholder of the corporation. If the controlling stockholder is a Filipino, then the investee corporation is likewise considered a Philippine national, right? So if the controlling stockholder is a corporation, then to determine if that corporation is owned or controlled by Filipinos. And what is the test? If the investor corporation is 60% owned by Filipinos, then it's considered Philippine national. And the entire shareholdings of the investor corporation are recorded as Philippine owned. Now, what about grandfather rule? When they applied the grandfather rule is applied if the Filipinos own less than 60% of the investor corporation. Or, as held in Nara versus Redmond, if on paper, the Filipinos own 60% of the investor corporation, and therefore 60% of the investing corporation likewise, if there's a doubt as to where beneficial ownership and control reside. If there's a doubt as to where beneficial ownership and control reside, the Supreme Court said you apply the grandfather rule. And when you apply the grandfather rule, only the shares that correspond to the percentage owned by Filipinos are recorded as Philippine owned, the rest recorded as foreign owned. Next. Correct. Now, this is a favorite question in the bar. Obviously, document of separate legal personality. There's so many questions. Let's simplify, or include permutations. So, ABC Corporation obtained a loan from XYZ Bank. The promissory note evidencing the loan signed by the president of ABC Corporation. Okay. If ABC does not pay, we all know that the lender, the bank, cannot run after the president, the one who signed the promissory note, because the loan was obtained by the corporation, not by the president, and they have separate legal personalities, as you all know. All right. Next permutation. The president, who's also the controlling stockholder of the corporation. The corporation, the borrower corporation, failed to pay. Does that give now basis to the lender, the bank, to run after the president because he's also the controlling stockholder? Again, the answer is no. With the fact that the president owns all of the capital stock of the corporation, it's not enough reason to disregard the seven legal personality of the corporation if there is no bad faith or gross negligence on his part, and the facts of the case, as I presented, do not show bad faith or gross negligence on his part. Next permutation. What if the president's sole stockholder sells all of his shares in favor of Pedro Reyes, making Pedro Reyes now the controlling stockholder of ABC, the borrower corporation? When the loan matured, the corporation refused to pay because accordingly, the loan was obtained but under the presidency of the former stockholder, no longer, not under presidency of Pedro Reyes. Pedro Reyes. Is that a defense? Not a defense, because the loan was obtained by the corporation, not by the controlling stockholder. The change of stockholder does not change the legal personality, right, of the corporation. It remains to be, the borrower remains to be the corporation despite change of stockholder composition, given that the corporation is taken separate from the persons composing it. Next. Next. Okay, next. Okay, next. These are all, as I told you, favorite question in the bar, right? Five times asked. Right? Next. Okay, next. Same concept. All right. Probably we can skip this part. It's so confusing. There are 6 cases, different jurisprudence. Anyway, it was only asked once in the bar, so not a favorite question. Next. Okay. Now, this one is a, well, kind of backtrack, Sarah. Okay, a permutation, another permutation of the same example we gave a while ago. All right. So, ABC borrowed money from a bank, secured by a mortgage on the property not of ABC but of XYZ. Right. The loan document and the mortgage agreement signed by different persons, the president of each corporation. Right. So the loan was not paid. As a consequence, the bank foreclosed the mortgage. After foreclosure, there is a deficiency. The proceeds of the sale not enough to cover the debt. So against whom may the bank collect the deficiency? There are 4 persons here: the borrower corporation, the mortgagor corporation, the one who signed the promissory note on behalf of ABC borrower corporation, and the one who signed the mortgage agreement on behalf of XYZ mortgagor corporation. So XYZ is a third party recommendation mortgagor. It did not obtain the loan, right? But ABC did. It only offered its property secured obligation of ABC Corporation. But there was a foreclosure, and then the lender would like to collect the deficiency. Is ABC, the borrower, liable for deficiency? Yes, of course, because it was the one who obtained the loan. It should pay the full amount of the loan. What about XYZ Bank? Sorry, XYZ Corporation, the mortgagor? Not liable to pay deficiency, right? Because third-party mortgagor is not liable to pay deficiency. Is obligation limited to the value of the mortgage property, unless there is contrary stipulation, or unless you can pierce the veil of corporate fiction, making ABC and XYZ as one and the same entity. But the facts of the case as I presented do not show grounds to pierce the veil of corporate fiction. What about the one who signed the promissory note on behalf of ABC? He's not liable because it's not his loan, but the loan of the corporation he represented. Corporate agents are not liable for obligation incurred by the corporation that they represent. What about the one who signed the mortgage agreement? Same concept, same principle. He's not liable. It's not his personal act, but an act taken on behalf of the mortgagor corporation. The corporate act of the agent, okay, does not make him liable. Instead, the corporation that he represents that will bear the liability, unless there is bad faith or gross negligence on their part, which is absent in the case that I presented. Next. All right. On types of shares is a favorite question. All right. You know very well if the holders of redeemable shares are not considered creditors of the corporation, same with preferred shares. Why is it that holders of preferred shares, even though you make those preferred shares redeemable, not creditors of the corporation? Because they're equity takers. The right to receive dividends is dependent on availability of surplus profit, right? If there's no surplus profit, the preference does not apply. Now, the moment though you have a surplus profit, then they're considered creditors of the corporation. That's what the Supreme Court said in Roy versus Herbosa. Without surplus profit, they are not creditors. The right to receive dividends dependent on availability of surplus profit. But the moment you have surplus profit, then they become creditor in the sense that they can compel the corporation from paying the dividends. What about redeemable shares? As you know, favorite question is that they can be redeemed regardless of the existence of surplus profit. Okay. Next. Okay, this one was asked twice in the bar. What in determining outstanding capital stock and therefore allowed to vote during stockholders meeting, what is your reckoning or what document will you use to establish the share ownership of the corporation? Is it the stock and transfer book or totality of the records of the corporation? it's not just the STB, right? But totality of the records of the corporation. What happened in this case? The articles of incorporation makes reference to founder shares, all right, issued to an incorporator, but it's not reflected in the stock and transfer book. What's reflected are only common and pref shares. So, do you include founder shares in computing your standing capital stock? And the Supreme Court said, yes. So, the entries in DIS are not conclusive to establish share ownership and therefore to determine quorum for a stockholders meeting. The records of the corporation will be taken into account in determining the issued shares of the corporation. Next. Okay, we can skip this part because of the amendments to the revised corporation code. Used to be a favorite question. Residency of the incorporators. Majority of them must be residents, as you all know. But the RCC eliminated the requirement of residency for incorporators, the requirement, the minimum number for incorporators for stock operation, right? And natural person no longer a qualification because juridical person can now be incorporator of a corporation. Next. Okay, we can skip this part. Well, this is a case, this is a question that does Mon Hernando again. Can kindly back up para sigurado lang. Okay, I need to qualify this. As you know, under the old law, a name that is deceptive cannot be registered with the SEC, right? So, if it is a corporation, you have to add the word corporation or incorporated as part of the corporate name, and you cannot adopt or include incorporation for a partnership or a sole proprietorship. It may lead to confusion. It's deceptive. Now, it's no deceptiveness or confusion similar with the corporate name is no longer the threshold requirement, right? As you know, it's now is the name distinguishable from a name that is reserved or registered for the use of another person or corporation. If it is distinguishable, the proposed name can be registered. If it's not distinguishable, then the proposed name will be rejected. Next. Okay, next. Okay, next. All right, now I included this, kindly backed up. This used to be a favorite question in the bar. What are the positions required of a private corporation? Which ones can be held concurrently? And you all know, corporation must have a president, secretary, and treasurer. The president cannot be treasurer or secretary at the same time. The treasurer can be secretary. The president cannot be both treasurer or secretary at the same time. Was the only exception in case of one-person corporation. The president can be self-appointed treasurer as long as he puts up a bond acceptable to the SEC. But he cannot be the corporate secretary even though it's a one-person corporation. We have to add though, if this should be asked in the bar, again, what are the positions required of a private corporation? President, secretary, treasurer, and don't forget to include compliance officer, right? For corporation imbued or vested with public interest. Next. Okay, this is 2011 bar exam. Again, time of justice, Mon Hernando. So this, I included this because as you know, it's now reduced to 3 years, di ba? Hindi na siya 5 years. You cannot extend the term of the corporation earlier than 3 years prior to the subsequent expiry date. The 3-year period applies to extension, not shortening of corporate term. You can shorten the term of the corporation anytime you want to, as long as you do it before the dissolution or before the end of the life of the corporation. But for extension, it has to be done not earlier than 3 years before the original or subsequent expiry date, unless there are justifiable causes that may warrant early extension as approved or determined by the SEC. Next. Okay, next. Well, I also noticed that Justice Hernando is I would say fond, no, of the requirements, the voting requirements for corporate acts under the code. So you may want to take a look or refresh your memory on the voting requirements. There are different corporate acts, as you know, with different voting requirements under the code. Either majority of the board of directors and majority of the standing capital stock, or majority of the board of directors, 2/3 of the standing capital stock, or you simply have majority of the quorum alone, or quorum plus both of the stockholders. So there are many voting requirements. Try to refresh to your knowledge of the same. Now, this one, pref shares can vote on the proposal to issue corporate bonds unless, of course, these are bond indebtedness. Bond indebtedness are not the same as bonds. Bond indebtedness are obligations secured by mortgage or encumbrance of corporate property. It's a long-term nature involving large number of lenders. If it's a bond indebtedness, then pref shares, even though non-voting, may vote, or non-voting pref shares may exercise the right to vote. But if it's only issuance of a corporate bond, an ordinary obligation of borrowing of the corporation, preferred shares that are denied the right to vote have no voting rights. It's not one of the 8 cases where they can exercise the right to vote. Next. Okay, on appraisal, right? Favorite question. Let's take a look at the questions on preemptive right. Okay. Can the articles of incorporation be amended to deny appraisal right to the stockholder? No, right? It's a right granted by law. What can be denied is waiver or lack of right of preemptive right. So the article may be amended to deny preemptive right, but the article cannot be amended to deny appraisal right, because that's a right granted by law. Okay, a question of Justice Mon Hernando, the waiver or denial of preemptive right must be in the articles, not only in the bylaws of the corporation. Otherwise, it is not valid. Okay. Now, another question. If shares are to be issued to new investors, ready, willing, and able to put in money to the corporation, is there a waiver of preemptive right effectively on the part of the corporation? Or is the corporation excused from offering the shares to the stockholders of the corporation? The answer is no, right? No. Issuance of shares to investor, even though he may be moneyed or rich, willing to put in money to the corporation, is not one of the grounds, not one of the exceptions for non-violation of preemptive right. So every time you issue new shares of the corporation, whether taken from the subscribed portion of the authorized capital stock, or in case of increase of capital stock, those new shares must be offered to the stockholders in proportion to their shareholdings in the corporation. Exceptions, as you know, many, if the right is denied in the articles of incorporation, in case of waiver of the preemptive right, especially impliedly, in case of issuance of shares to comply with laws requiring stock ownership by the public, in case of issuance of shares in payment of a debt, and issuance of shares in exchange for property needed for corporate purpose, provided that for the last 3, meaning payment of debt and acquiring property, the issuance of share must be approved by stockholders representing at least 2/3 of the standing capital stock. And issuance to an investor is not one of them, right? Now, let's say another permutation. What if the issuance of shares to an investor is ratified by the stockholders owning 99.9% of the corporation? Can the 1% owner claim denial of preemptive right? What happened, Sarah? Nawala yung slides. I lost the slides, Sarah. Anyway, Sarah is trying to find the slides. The answer to that question is the remaining 1% can claim violation of preemptive right. Because we said the issuance of shares to an investor even though ratified by 99.9% of the stockholders, is not one of the 5 cases where you can issue shares without violating preemptive right of the stockholders. Sarah, what happened? Sorry, let's wait for the slides. Okay. Merong distraction dito. Okay. Okay. Right. Okay, 2011 bar exam. Again, just one Hernando. So as I told you, so this is one of his questions. The denial of preemptive right must be in the articles, not only in the bylaws. Next. Okay, another favorite question, the bar, regarding disposition of corporate assets. Okay, so you know very well that if the corporation will sell its assets in the ordinary course of business, board approval suffices. By board approval, we mean majority of the quorum, right? However, if the sale or mortgage or assignment or transfer involves all or substantially all of the business or assets of the corporation, then it requires approval of the board by at least majority vote, not just majority of the quorum, and both of the stockholders representing at least 2/3 of the standing capital stock, right? And you have to comply with the bulk sales law. So what do you mean by compliance with the bulk sales law? So you must give the notice to the creditors at least 10 days before the sale, so they can take the measures to protect their interest, and inventory of goods must be filed with the DTI. So the list of creditors must be under oath, right? Given, of course, to the buyer, must be under oath that includes due date and amounts of obligation owing to each of them. And then notice, of course, be given likewise to the creditors concerned. The consent is not required, but notice be given to them. Otherwise, the sale did to be in fraud of creditors and null and void, in which case the transferee or the buyer becomes the trustee of the goods or the property sold in trust for the creditors of the corporation. And when you say that the sale is in bulk, if the sale amounts to all or substantially all of the business or trade, or amounts to all or substantially of the assets of the corporation, or a sale, transfer, assignment not in the ordinary course of business. Okay, next. Okay, now still on sale of assets, another favorite question is, in case of sale of all of the assets, does that make the buyer corporation liable for the obligations of the seller corporation? Does that result in dissolution of the corporation? Let's take a look at those questions. Number one, is the seller corporation deemed dissolved if it sells all of its assets or business to the buyer corporation? It does not, because sale of assets or business is not one of the modes of dissolution under the revised corporation code. Right. Now, what about the second one? What about the buyer corporation? Is it obligated to assume all the liabilities of the seller corporation, the so-called Nell doctrine? The answer is no, unless there is stipulation. meaning the buyer assumes liability. Second, the sale amounts to fraud. Third, the buyer is a continuation of the personality of the seller corporation, or the so-called business enterprise transfer rule. And the fourth, if the sale amounts to a merger or consolidation, in which case the buyer, as surviving corporation, will assume all the obligations of the buyer as the similar to the surviving entity in the merger, will absorb all the obligations of the seller corporation akin to the absorbed corporation. Next. All right, I told you. So there's one favorite. He's one fund of boarding requirements, 2011 bar exam. I also saw this in 2009. So when it comes to cash dividends, majority of the quorum suffices. It's not even majority of the entire board. Majority of the quorum is enough. What do you mean? If you have 15 directors, 8 are present, you have a quorum. Can the 8 approve the cash dividends? Yes. All right. Now, what about 5 out of 8 only? Yes, right? Because the law requires not majority of the entire board, but majority of the quorum. For stock dividends, majority of the quorum and 2/3 of the standing capital stock. Next. All right. Well, this is more codal, so we can skip this part. Cases where you can withhold declaration of dividends. Next. Okay. Favorite question. Dividends can only be declared out of surplus profit or retained, unrestricted retained earnings. 2009, as I told you, Justice Mon was also the examiner. Next. Here, 2009. When is there an ultra-virus act on the part of the corporation, the board of directors, the corporate officers? Okay, so there is ultra-virus act on the part of the corporation if it performs an act that is outside the express, implied, or incidental powers of the corporation. The ultimate test is whether or not the act is in furtherance of the corporation, germane to the interest of the corporation. If it is not germane to the interest of the corporation, not furthers the purpose of the corporation, and therefore outside the express, implied, or incidental powers, it is ultra-virus. What about the board? When does the board commit an ultra-virus act? If the board engages in an activity without ratificatory or affirmative vote on the part of stockholders, in those cases, the law requires approval of the stockholders. Like example, amendment of the articles of incorporation within the power, of course, of the corporation, therefore not ultra-virus, right? The board alone approves it without corresponding stockholders' approval. Or stock dividends, the board alone approves it, no stockholders' approval. These are ultra-virus act on the part of the board if they carry out the amendment and the stock dividend because there is a lack of ratificatory vote from the stockholders. Or also asking the bar, what if the stockholders declare cash dividends? Ultra-virus, right? Because stockholders cannot declare cash dividends. Only the board can. The stockholders may declare stock dividends with prior approval, of course, of the board by majority of the quorum, but stockholders cannot declare cash dividends. What about corporate officers? When are they deemed to perform ultra-virus act? If they exceeded the scope of their authority. Either they have no authority or exceeded the scope of their authority. Next. Okay. Well, other than 2019, 2015, because I started my book is only 2009, right? Bar exam questions. Before 2009, there were so many questions trust fund doctrine. You might say it's the ultimate favorite on corporation law. So what is the trust fund doctrine? It provides that subscriptions to the capital stock of the corporation are funds held in trust for the benefit of the creditors. And therefore, the subscriptions to the capital stock of the corporation cannot be returned to the stockholders. They're supposed to be, they're supposed to answer for claims of creditors. That's why cash dividends cannot be declared out of the subscriptions, right? It can only be declared out of the surplus profit of the corporation. Or the corporation cannot acquire its own shares using its own using the subscriptions of the stockholder. There must be surplus profit, right? Now, the trust fund doctrine is expanded to include properties of the corporation. What do I mean? So there are now two components of the trust fund doctrine. The first component is subscriptions to the company stock are funds held in trust for the benefit of the creditors. They must be unimpaired. Second component, the properties of the corporation are likewise held in trust for the benefit of the creditors. In what sense? They cannot be distributed to the stockholders except in case allowed by law or equity. What are those cases? Dissolution or liquidation of the corporation, reduction of company stock, and redemption of redeemable shares. If you distribute properties to the stockholders, except those cases allowed by law or equity, you violate likewise the trust fund doctrine. Next. All right, now just crossed my mind, so probably it's important, baka inspiration ng Holy Spirit, no? Also the trust fund doctrine, given that these are funds in trust for the benefit of the creditors, as you know, may file an action to enforce payment of the unpaid subscription, right? That this question, the bar, a permutation of trust fund doctrine question. You have three stockholders or three subscribers. One fully paid the subscription, B partially paid subscription, C fully paid subscription, but also director of the corporation. The corporation collapsed, and based on the evidence, it collapsed because of the bad faith or gross negligence of the directors, including C. Can the creditor run after A, B, and C? A, no more, because he has fully paid the subscription. B, yes, because he has partially paid subscription. And under trust fund doctrine, the creditor may enforce payment of the unpaid subscription, because these are funds held in trust for the benefit. What about C? Fully paid subscription, but also director of the corporation. He is no longer liable as a subscriber having fully paid subscription, but he is liable for his gross negligence of bad faith conducting the affairs of the corporation. As in case of bad faith or gross negligence on the part of director or officer, they shall be liable with the corporation. Now, this one, also question of Justice Mon Hernando, ito non-stock corporation. So there are 6 members of the board to be elected. So X, Y, and Z, or minority members of the foundation, which exercise cumulative voting in order to protect the interest, although the foundation articles and bylaws are silent on the matter. As to each of the 3, what's the maximum number of votes they can cast, or he or she can cast? As you know, if there are 6 to be elected, as in this case, then a member can cast 6 votes, as long as he cannot vote more than once for a candidate. So he has 6 votes, right? But he can accumulate all of the 6 votes in favor of one nominee, unless it is allowed by the articles or bylaws of a non-stock corporation. No such thing as cumulative method of voting, as you know, in non-stock corporation. It's present for stock, but not for non-stock corporation. Next. I think we have covered it. Okay, 2009. I think we have covered this, no? On pref shares and redeemable shares. 2009 again. That's Mon Hernando, the examiner. Next. Okay. On appraisal rights. So is the value of the shares before a day before the vote was taken, regardless of the appreciation or appreciation in the value of the shares. Next. Okay, we have taken this up. Next. Okay, next. We'll take them up together. One. Next. For 2011 bar exam, as you know, in case of disagreement, The fair value is determined by the corporation and the stockholder. In case of disagreement, 3 appraisers should be appointed, 1 chosen by the director, 1 chosen by the stockholder. The third one is a disinterested party chosen by the nominees of the corporation and stockholder. The wife cannot be the third party because she's not a disinterested person. 2011 mark again. Okay. Okay, this question in relation to the one we said we skipped a while ago. So what is remedy available to stockholder so that he will get to know what's happening, of course, in the corporation. We all know it's a right of inspection. Okay. So all right. What are the allowable purposes or proper purposes for inspection? When you exercise your right of inspection, you have to have a legitimate purpose. You cannot just say, I want to inspect the records because I'm a stockholder. As a stockholder, I'm entitled to it. No. So you have to indicate your purpose. And the purpose must be allowable by law and jurisprudence. What are the allowable purposes? So to determine the financial condition of the corporation, determine the value of your shares, and then obtain list of stockholders for proxy purposes, to obtain information in aid of litigation with the corporation, and determine if there's been mismanagement of the corporation. Right. So what about, are you entitled to all the records of the corporation? Yes, you are, but you indicate the purpose of your inspection. You cannot just say, I would like to satisfy my sense of curiosity. Not allowed. Supreme Court said it must be germane to your interest as a stockholder of the corporation. And then, of course, other than having a proper purpose, there are other limitations, as you know. The right must be exercised during reasonable hours and business day. And the stockholders must not improperly use information, secure the previous examination. He must be prompted by good faith, not by ill motive. And his right of inspection, of course, subject to other relevant laws like intellectual property and RA 1405. It can extend to trade secrets, can extend to deposits. These are previous information under relevant special laws. Next. Okay, we have covered this. Next. Okay, we have covered this preemptive right likewise. Next. Okay, another favorite question in the bar regarding right to vote. I think this was 3 times asked. Pag 1 lang natin sinasama, they've noticed. So, minimum 2. Ito 3 times. These are the variations of the the question based on this principle. So let's say a subscriber subscribed to 100,000 shares, paid only 25,000. Okay. How many shares can he vote? 100,000 or 25,000 only? We all know the answer. 100,000. So the measure of standing of the stockholder is his subscription, not the shares he paid. Okay, next question. The due date of the payment of the unpaid subscription is June 1, 2023. Right. On June 10, the corporation called a special stockholders meeting. Can the subscriber exercise the right to vote? And if yes, how many votes or shares can he vote? Can he vote 100,000 or just 25,000? Because he did not pay the subscription on due date, right? June 1, due date, June 10, stockholders meeting. Answer, the entire 100,000 subscription. Because non-payment on due date does not make the shares delinquent. Holders of unpaid shares that are not delinquent have all the rights of a stockholder. Okay, next. After 1 more week, that is June 15, due date is June 1, right? The corporation declares cash dividends. Is the subscribed entitled to cash dividends? If yes, how many? The answer is he is entitled to cash dividends for the entire 100,000 shares. Why? Because he is not delinquent. He may have been unpaid on June 1, but unpaid shares have all the rights pertaining thereto. Holders of unpaid shares that are not delinquent have all the rights of a stockholder. And shares become delinquent not upon non-payment on due date, but after 30 days from due date. Right. Next question. The last one. Can the corporation apply the cash dividends against unpaid subscription? Di ba, meron siyang utang na 75,000, di ba? Binali niya 25,000 of the 100,000 shares subscription. Meron kayong cash dividends. Pwede ba apply ng corporation yung cash dividends against unpaid subscription? And the answer is no. Why no? Because the corporation code then and now allows set off only for delinquent stocks. So unless there is a stipulation allowing the corporation to set off, the corporation cannot just apply the cash dividends against the pay subscription unless the stocks become delinquent. Okay. Next. Okay, this cumulative. Okay, regarding preferred shares and right to receive dividends. All right, another permutation or variation. What if the prep shares are cumulative? Cumulative, meaning, let's say there are 3 years based on terms of the prep shares. Every year, the holders get their cash dividends based on the yield indicated in the issuance, and of course, given availability of surplus profit. Year 1, no dividends were declared. If they're cumulative, they're carried over, right, to the second year. If on the second year, again, no dividends declared, they're carried out to the third year, such that on the third year, the holder gets the cash dividends for the first, second, and third year, assuming, of course, there is surplus profit. If the surplus profit is available only to cover the dividends on the year it was declared, it does not accumulate, right? Despite the cumulative nature of the pref shares. So there's only cumulative feature, and that can be enforced only if the surplus profit is enough to pay for all of those accrued or accumulated dividends. Right. Another variation. Merong profit na natitira, no? Pambayad sa nag-accumulate na dividends, profit. So can the corporation be compelled to pay the dividends on those shares that, I mean, where no dividends were declared on certain year? And the answer is no. Why no? Because the test is not just availability of profits. The test is availability of surplus profit. Profit is not the same as retained earnings, as you all know. Next. Okay, and this is 2009. The concept of derivative suit. Another favorite question in the bar. We all know that once a person owning one share can file derivative suit, right? It's a remedy available to minority stockholder. Don't forget what I told you if you attended my lecture on recent jurisprudence, Ago Realty versus Ago. Supreme Court said derivative suit is available only to minority stockholder, right? Not the majority stockholder. If you belong to the majority, your remedy is to cause the board to adopt a resolution to authorize the filing of a legal action. So this one, the question is, he only owns one share. So even though he's a significant stockholder, he can file derivative suit on behalf of the corporation. What happened here? The property was sold for a song, meaning lugi, yung corporation sa pagbenta ng property. Would the suit prosper? Why or not? For the suit to prosper because he's enforcing a cause of action available to the corporation. If the property is sold for a price that is not reflective of current market value, the harm is to the corporation, right? And the ones who approve it are the ones in control of the corporation. They're not expected to set aside the wrongful act. That's why any stockholder belonging to the minority can take the cudgels for the corporation, file an action on behalf of the corporation to set aside the wrongful act. Third question. Third question. There's a letter C here. Oops. Okay. will the suit prosper? So keep this in mind. Even though he is enforcing a cause of action, even though he can file the derivative suit, it is important to allege in the complaint all the elements of the derivative suit. Now, this question, this part of the question on the derivative suit is yet to be asked. So it's not a favorite question, obviously, right? The derivative suit is, but not this question. What are that question? What is that question that is yet to be asked? Elements of the derivative suit. What are the elements? Don't forget C. Sena. C. Sena. C. Corporate right or cause of action. The suit must be filed in the name of the stockholder of the corporation to enforce a corporate cause of action. S. Stockholder. The plaintiff must be a stockholder at the time he filed the complaint and the cause of action accrued. E. Exhaustion of intercorporate remedies. N. Not a nuisance or harassment suit. A pressure right is not available. Next. 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 Okay. Now, this one is a combination of business judgment rule and derivative suit. I thought I should include this because of the business judgment rule. Given that Judge Monernando wrote a decision, remember that case of Berhad versus Sinofil Corporation on business judgment. All right. So what is business judgment rule? It means that questions of policy and management are left to the sound discretion of the board. The court, stockholders, SEC cannot interfere with the board when it comes to questions of policy and management. Right? What happened here? The corporation obtained a loan. So give a mortgage on the property, and on maturity of the loan, corporation had no money to pay the obligation, and the lender threatens to foreclose the mortgage. To stay for foreclosure, the corporation decided to sell its treasury shares for a price below below par value. Let's say below par value, right? But that's the best price. It can be fetched under these circumstances. Okay. The stockholder complains that the shares of stock, the treasury shares, should not have been sold for that price. Can he file a derivative suit on behalf of the corporation? Well, first, there is nothing wrong with selling treasury shares below par, even below book value. Why? If that's the best price that can be sold or obtained under the circumstances. Keep in mind, treasury shares are not subject to watered stock doctrine. Treasury shares are assets of the corporation. The properties of the corporation, they can be disposed of by the corporation upon terms approved reasonably by the board of directors. If the board thinks that's the best price under the circumstances and they need the money to pay off the threatening or foreclosing mortgage, then the sale is made in exercise of best business judgment. Therefore, valid. Next. Okay, next. 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 Okay, we've taken this up. Next. Next. Okay, finish. Okay, finish. Okay, next. Okay, this also, well, it's just 2015, but there was another one, I think 2019 or 18, about apparent authority. So what do you mean by apparent authority? So by this doctrine, it means that the corporation will be stopped or precluded from denying the agent's authority if the corporation vests title in this agent and holds his authority to the public. So basically, the corporation holds out to the public that this person is authorized to transact business on behalf of the corporation. And as a consequence, even though there is no board resolution authorizing this officer, he does not derive his authority under the bylaws of the corporation. His act is just same binding on the corporation. So this doctrine assumes there is no board resolution affirming his authority. There is no bylaws provision giving him authority. And yet, despite the lack of these two, his action is authorized by the board. Why? The board, in effect, ratified the authority of this officer or this agent by holding out to the public his authority to act on behalf of the corporation. Next. Okay, next. Okay, we can skip this part. 2011 bar examination. This becomes relevant in view of the power of the SEC to remove a director, right, for lack of qualifications, or qualification surface only, or disqualification surface only after the election. So this one, disqualification by operation of law. So a law was passed disqualifying former members of Congress from sitting in the board of GOCC. Does this need approval of the stockholders owning 2/3? The answer is no. But what I'm saying is, disqualification based on law need not be approved by stockholders owning 2/3 of the standing capital stock. A director can be removed, as you all know, right? By the vote of the stockholders owning 2/3. But if the removal is based on disqualification under the law, that can be carried out despite lack of 2/3 of the standing capital stock, or despite lack of stockholders' approval representing 2/3 of the standing capital stock. Well, we have no more time. We can skip this part. I have 20 minutes. So this a motion is I think this concept not found in the corporation code. A motion means premature ousting of a director. So counterpart is removal of a director under the code. What is important to stress though is that a director can be removed, but there is no mechanism for the removal of a stockholder. The stockholder can be taken out only if it does not pay the subscription, right? Shares can be sold at auction, and if the corporation acquires these shares, if there's no bidder, they become treasury, then stockholder is out. But if stockholder is fully paid subscription, he can be taken out or removed from the corporation because there is no such mechanism under the law, at least up to today or up to now. None yet. Next. 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 Okay, I have to be selective even because I only have 20 minutes. No? This one, twice asked in the bar regarding you all know that directors of a stock operation serve for 1 year, right? Until their successor elected and qualified. The term is 1 year until their successor elected and qualified. So if there is no stockholders meeting that ensued, the incumbent director shall serve in a holdover capacity, as you know, right? Now, what happens if a director resigns during the holdover period? How do you fill up the vacancy? Africa versus Valley Verde Golf and Country Club. If the holdover director resigns during the holdover period, the vacancy is created not by resignation but expiration of term. And therefore, the vacancy can be filled only by the stockholders, not by the board. The board may fill the vacancy, as you know, in case of resignation. But this one is not resignation. It's expiration of term. What do I mean by that? Or what does the Supreme Court mean by that? The term of a hold of the director has already expired. The term, remember, is only 1 year, right? 1 year. The phrase until their successor elected qualified is the holdover period. It's not part of his term. Okay? That's why if he goes during that period, the mode of vacancy is created not by resignation but expiration of term. And as you know, the cost expiration of term, on the stockholders may fill the vacancy. Next. 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 Okay. it's by quorum is, of course, majority of the board is fixed in the articles, not fixed by the bylaws or not fixed by the board, but fixed in the articles of incorporation. Okay, I'll just be selective. I only have 20 minutes left. Okay. This is also a favorite question in the bar regarding requirements for valid transfer of stock. So, you know, there are formal requirements and requirement of recordation or registration in the books of the corporation. The stock certificate must be endorsed and delivered, right? It binds the contracting parties, but divide the corporation and third world or third person, sorry, it must be recorded in the stock and transfer book, showing the date, the names of the parties, the contract or transaction, the shares covered, the stock certificates, stock certificate number, and other relevant information. If not recorded, it doesn't bind the whole world nor the corporation. Yeah. Now, permutation or variation of this principle, what is the remedy available in case the corporate secretary does not register the share? The remedy is one of mandamus, to compel the CORSEC to do a ministerial act. Now, who can file a petition for mandamus? The more recent case, as you know, or asked in the bar, is either the transferor or the transferee may file a petition for mandamus. It used to be only transferor. The transferee has no standing yet in the books of the corporation. The transferee may register the transfer only if authorized by the transferor, not anymore. In Rural Bank of Andaya versus Rural Bank of Kabadbaran, 2016, Supreme Court said either of them may file a petition for mandamus. Next. Okay, next. What are stock issued for a price below par value for par value share or issued less than issued value for no par value shares. For issuance of water shares, you know, the subscriber and consenting directors are liable solidarily to the corporation or the creditors of the corporation. Next. 15 minutes. Okay, I'll just choose, if you don't mind, because we don't have time. Next. Next. Right, done. Okay, next. Right. Okay. Now, regarding dissolution, also, as you know, also a favorite question in the bar, just keep these basic principles in mind for dissolution. If the corporation is dissolved, whether voluntarily or involuntarily, right? There's a 3-year period to liquidate and wind up the corporate affairs. All right. But the 3-year period is not mandatory. Let's say, can the corporation sell a property as part of liquidation more than 3 years from dissolution? Yes. Right? As long as, well, it's intended to carry out the dissolution and carry out the liquidation of the corporation. Doesn't matter when. What matters is it is done, the liquidation. So given that principle, based on jurisprudence and SEC opinions, don't forget these basic rules. Any action or suit filed against the corporation or by the corporation after dissolution is valid. 3-year liquidation period also valid. Why? Because no right or remedy available to or against the corporation shall be impaired on account of dissolution. Whatever right or remedy available to the stockholder of the corporation may be enforced even after the dissolution of the corporation, as long as it is filed during the lifetime of the corporation or during liquidation period. It can be continued beyond 3 years from dissolution. What about an action filed after 3 years from dissolution? This time, the corporation lacks legal personality to sue and therefore has no more cause of action. So keep that principle in mind. During the lifetime, it can go on beyond 3 years, the suit that is, or during the liquidation period, the suit was filed, it can go beyond 3 years from dissolution. But the suit filed after 3 years from the solution, no more. Corporation, no more legal personnel to sue and has no cause of action. Next. 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 Okay, not part of the bar anyway. No, this is part of the bar. So pag itong corporation sole, ito madalas yung tanongin, the presiding bishop organized himself in the corporation sole, was organized into a corporation sole. That corporation can sell, can own or acquire private land in the Philippines regardless of the nationality of the controlling or the head or the bishop, as long as 60% of the members are Filipino citizens. Next. All right, on foreign cooperation, of course, the most important and often asked question is doing business. So what do you mean by doing business? So there is no definition, it's by enumeration. So for lack of time, regarding importation, exportation, importation of goods or exportation of goods per se, without any activity being done in the Philippines, does not amount to doing business. And if it doesn't amount to doing business, therefore the foreign corporation may sue despite lack of license from the SEC. Okay. Now, for doing business, what I would like you to focus on is investment in equity. So mere passive investment in equity is not doing business. That we don't need license to do business from the SEC if you're a foreign corporation wanting to buy or acquire or subscribe to shares of stock of a domestic corporation, or if you will exercise your vote as a stockholder of the corporation, or if you will collect dividends owing to the foreign corporation, any right emanating from investment equity may be enforced by the foreign corporation despite lack of license to do business. Next. Next. Oh no, next. 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 Okay, next. Okay, next. Okay, next. Okay, let's move on to banking. I only have 10 minutes. Next. Okay, this is a favorite question of our conservator receiver. Okay, just keep this in mind because of changes in the law and recent jurisprudence likewise. Conservator is appointed if the bank is in a state of lack of liquidity adequate to protect interests of stakeholders. Liquidity means having more assets than liabilities, but foreseeing the impossibility to pay the debts as they fall due. Receiver appointed generally in case of insolvency. There are many grounds, but generally appointed in case of insolvency. Assets less than liabilities. Okay. Conservator given 1 year to restore the bank to its former state of viability. If the conservator does not and cannot rehabilitate the bank, then he can recommend the closure. And once so recommended, the BSP may close the bank without the need of conducting a separate audit examination of the bank. This is what Justice Mon Hernandez said in his this was 2009 bar examination based on the Supreme Court decision, of course. So the central bank BSP may close a bank upon the report of the conservator or the head of the supervision examination department. And it's not a lack of due process to rely or adopt the finding of the conservator or the head of the supervision examination department, no need to conduct a separate audit examination of the bank. Okay. Now, going back to distinction of conservator receiver, so first distinction, conservator illiquidity, receiver insolvency. Conservator 1 year to restore the bank to state of viability. Receiver under the old law given 90 days to rehabilitate the bank. Not anymore. Under the new law, once a bank is placed under receivership, meaning receiver is PDIC, of course, it should proceed right away to liquidation. The option to rehabilitate the bank is removed under the new law. And the last distinction is, if conservator is appointed, the bank may continue business. Because the conservator will just take the place of the board directors and management. But once a bank is placed under receivership, it cannot do business. It's not. It's forbidden to do business and must proceed to liquidation of its affairs. Next. There you go. This is what I said. Next. Okay, same. 2009, remember. So just Mon is the examiner. Next. So law and secrecy of bank deposits. Sorry. Next. 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 Okay. Now, this one, regarding ombudsman, no? So, given so many cases filed by the ombudsman against public officials, just keep this principle in mind. Again, 2009 bar examiner, si Judge Mon, right? Can the ombudsman examine bank deposits? Can the ombudsman order the in-camera inspection of bank deposit and records pertaining thereto? The answer is no. So, ombudsman cannot examine bank deposits without complying with these requisites. Number one, there must be a case pending before a competent court. Second, the account to be examined must be identified. Third, notice given to the account holder, the bank official. And fourth, examination limited the account specified. So what does the first mean? It means that there should be a case pending before the Sandigan Bayan. Once it is with the Sandigan Bayan, it can ask for a subpoena from Sandigan Bayan to examine bank deposits. But at its level, at the level of the ombudsman, there's no power yet to examine bank deposits. Next. Oh my, next. Okay, now money laundering in relation to bank deposits, mere suspicion that a person or a bank deposit is engaged in legal activity does not justify the AMLA from looking into the deposit, right? So the AMLA cannot direct the bank to provide information, more information on a deposit because of suspicion of corruption or bribery. The AMLA needs a bank inquiry order to be able to examine and look into deposits of a person where there's a probable cause of commission of unlawful activity under the anti-money laundering law. So the only instance where AMLA may dispense with the bank inquiry order and direct the bank to provide more information is if the predicate crime is HKT-MAD. Remember, hijacking, kidnapping, terrorism, murder, arson, and dangerous drugs law violation. In any of these cases, the law says the AMLA does not need a bank inquiry order and correspondingly require the bank for more information. Next. Also keep this in mind, favorite question the bar regarding garnishment. Philippine currency deposit can be garnished and therefore the bank can disclose information about garnished deposits. Pag foreign currency deposit, it cannot be garnished. It's exempt from garnishment, exempt from court order. In fact, the only instance you can inquire, look into foreign currency deposit, of course, written permission of depositor, court order for violation of the Anti-Money Laundering Law and Anti-Terrorism Act. But there are other exceptions by jurisprudence, but just suffice it to say that when it comes to foreign currency, it's exempt from garnishment as opposed to Philippine currency bank deposits. Next. Okay, General Banking Act. Okay, favorite question, the bar, of course, different kinds of bank, universal commercial, trade bank, Islamic bank, cooperative bank, and the banks may be classified by the SEC. This one, can a commercial bank, can a bank invest in cement manufacturing? The answer is, well, it cannot, right? Because a bank cannot engage in cement manufacturing. They're incompatible with each other. But the question is, can a bank invest in the equity of cement manufacturing? Can a bank be a stockholder of a cement manufacturing company? The answer is, it depends. If it is a commercial bank, no. Universal bank, yes. Because commercial bank can only invest in the equity of allied and non-allied undertaking. Universal bank may invest in the equity of allied and non-allied undertakings. Next. Now, the favorite question in general banking, of course, definition of bank 3 times also asked in the bar. What are the elements of banking? Entity engaged in lending of funds. Second, obtained from the public. And third, in the form of deposit. If these 3 are present, that entity is engaged in banking, and without license authority from the BSP, co-warranty may lie against that entity. Right? Permutation. So a bank issues bonds to the public and use the money to finance its operations of buying at a discount promissory notes. Is ABC a bank or engaged in banking? No, because there is no deposit-taking activity. In our example, issuance of bonds is not deposit-taking activity. All right, another permutation. A bank or a corporation buys at discount promissory notes of cars and realty. And this promissory note with a check included in it, discounted or negotiated by the corporation to a finance company. So the maker of the promissory note refused to pay, arguing that the payee is engaged in banking with the authority from BSP. Is the payee engaged in banking by the act of negotiating that promissory note in favor of finance company? The answer is no. Without deposit-taking activity, without funds from the public to deposit, there is no banking. Next. Oh my God. Okay, next. Next. Okay, we can skip next. 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 Okay, next. Next. A second. Okay, next. Intellectual property. Next. 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 I just have to be I have to choose na lang. So, okay. I just choose one for intellectual for trademark. Sarah. Pakibalik lang sa trademark lang. Okay. Well, probably what we can do is distinguish, right? Distinguish that, because that's a favorite question, obviously. Trademark, copyrights, and patent. Kindly backtrack, Sarah. And let's make the distinction one more. There you go. Let's make the distinction in the light of recent jurisprudence. So first, what is a trademark? Any visible sign capable of distinguishing goods or services, in which case is called a service mark. It includes a stamp, mark, or container of goods. Right. What about copyright? In copyright granted by statute to the originator or creator of certain literary, artistic, scientific, or scholarly works, whereby it's invested for a certain period of time, uh, a combination or collection of more economic rights on the terms granted by statute. What about patent? Any technical solution of any problem, any field of human activity that's new, requires inventive step, and thus the applicable may be patented. Next. Okay, next. As to object, the object of trademark, of course, goods or services. W copyright is original literary and artistic work. W patent is invention. As a term, trademark is good for 10 years, can be renewed for in increments of 10 years. Copyright is generally 5 years, 50 years, I'm sorry. The only time that copyright is more than 50 years, of course, right of attribution, which is in perpetuity. Broadcast, 20 years, applied art, 25 years. But generally, it's 50 years, except for those that I mentioned. Patent, 20 years from filing. As to how acquired, this is why I see as a potential bar exam question, given the times they were asked, and the recent jurisprudence, of course. Trademark is acquired through registration, no longer use. Registration, based on Sudica versus not the farm. Right? Trademark is acquired through registration as long as done in good faith. It's no longer the first one to use, but the first one to register. And therefore, the first one to register in good faith defeats the right of the first user in good faith. But if the registrant is aware of the prior use of a trademark by another, registration is done in bad faith, and therefore certificate of registration may be cancelled. Copyright acquired at the moment of creation need not be deposited with the National Library or now with the IPO. The deposit with the National Library only creates a presumption of ownership, but not a condition precedent to enforce the right on the copyrightable works. Patent acquired through, of course, obligation with the IPO. And also, for trademark, used to be a favorite question, dominancy test and heuristic test. There were questions on when to apply dominancy and when to apply heuristic test. Now, of course, that's already moot in academic because, as you know, as held in a Colin, Taiwan Colin versus Colin Electronics, in an en banc decision, the Supreme Court abandoned the heuristic test. There's only one test now to determine if two trademarks are similar with each other, causing confusion to the public. That is dominancy. Dominancy is based on Section 155.1 of the Intellectual Property Code. It means the imitation of the or reproduction of a trademark or dominant feature of the trademark in relation to sale of goods or offering of goods for sale to the public. Okay, so I guess I am making myself available for questions, if any. Sorry that I had to skip to the other slides because of lack of time. It's now 3:40 on my watch. Okay. Louis.
We would like to extend our heartfelt appreciation for our lecturer for today for that comprehensive and insightful discussion. And for sure, a lot of our barbaristas have been refreshed by your guidance, Dean, for the upcoming bar examination. At this moment, we'd like to open the floor to the audience in our Facebook Live. If you have any questions for Dean Divina, please comment it down. Thank you. Because personally, I don't have any questions as I have not yet taken commercial law. But one of our baristas in the PUP College of Law would like to ask you, Dean.
UP.
This is regarding banking laws. If na-violate Bank Equal Protection Clause since foreign deposits are exempt from garnishment, pero PH deposit po daw hindi. What is the basis of their substantial distinction daw po?
Sorry. Can you kindly repeat, Louis?
Regarding banking laws, if na-violate ba yung Equal Protection Clause since foreign deposits are exempt from garnishment pero PH deposit hindi? What is the basis of their substantial distinction?
Okay. So it's a question that combines commercial law and political law, right? I like it. So there is no jurisprudence yet. But the reason why a different kind of treatment is accorded to foreign currency deposits is because we need those type of deposits to beef up our international reserves. That reserve, as you know, used very important for facilitating foreign exchange transactions. We don't that kind of rationale does not apply or exist when it comes to Philippine currency deposits.
Thank you. Another question po din. When the BOD from J-Vit Capelan from our Rex live, someone asked po, when the BOD tries to out a member, is the subject director entitled to counsel in the meeting called for the purpose?
Okay, so that has not been asked in the bar, obviously, but he's not entitled to counsel because board meeting is not a court. It's not a court proceeding, and the law allows the stockholders meeting is not a court, not a court proceeding, and therefore the stockholders can limit the participation attendance only to stockholders. And the law allows stockholders to remove a director by the vote of 2/3 with or without cause. The only requirements of cause or the only instance where a just cause needed if the director to be removed belongs to the minority. So the director to be removed has no cause for complaint because the law allows stockholders to effect the removal. Now, it's a good question though regarding the board. The board, as I've said before, the amendment to the RCC, only stockholders can remove a director. Board cannot remove a fellow director. So if a director is being absent consecutively, not paying his dues to the corporation, the board has no choice. He cannot be removed by his co-directors. He can only be removed by the stockholders. But the non-attendance during board meeting, non-payment of dues, or violation of the bylaws of the corporation, for example, may be the just causes to warrant its removal. So even though it belongs to the minority, it can be removed. Now, the thing is, under the RCC, the board of directors may remove a director if the disqualification surfaces only after his election. Because if the director does not remove him, then he will be held responsible or liable to the SEC.
Thank you, Dean. One last question, from one of our baristas, and might ask as well in the bar if it's okay for it to answer as well, Dean.
Sure.
Is the name of a TV show a subject of copyright or trademark?
Oy,
Where do you draw the
oy,
line?
delikado yata yun. Delikado yata yan. So, I'm the lawyer for Tito Vic and Joey. So, it's sub judice. It's pending with the court right now, no? So, I do not know if I'm entitled. I don't think I'm entitled to comment on that unless I be
I see.
entitled for contempt. I well, I like that.
So we'll
It's a
skip that.
debating me to give my thoughts, no? I'm sorry I cannot because I'm the
It's okay pa din. Just asking because it might
pending
ask for in the bar.
pending
But
with the Sige.
last message pa to our baristas, Dean.
Mm. Well, the message that I have for my children-in-law, I consider my students, bar reviewees who attend my lecture as my children-in-law. You're almost there, right? You're almost there. I know you're very exhausted. I know you're very tired. But whatever is your motivation for aspiring to be a lawyer, hold on to it until the very end. If you feel like giving up, think of the motivation that made you here in the first place. You want to help in the dispensation of justice. You want to fulfill the wish of your father or your mother or your girlfriend, or you want a good life that, that lawyers are sort of known for. Whatever may be the motivations, hold on to them until the very end. So don't give up. Don't give up. And we're going to pray for you. I have said this many times. Those who listen, those who attended my lecture are included in my prayers that you all pass the bar examinations and of course you live a happy life.
Thank you again, Dean. That message will surely help them and will give them the strength to pass the bar examination. So may I remind everyone that for our next discussion, thank you, Dean, again. That concludes, I guess, the discussion. So for our next discussion,
So I can leave na, no? Louis, I can leave na. Okay, thank you. Bye.
yes, yes. Thank you, Dean. Again, everyone, thank you for attending the discussion. So for our next discussion, that would be labor law on September 1 with Dean Duca, legal ethics on September 4 with Dean Grapilon, and remedial law for special procedure on September 7 with Dean Festin. So again, please don't record or reproduce these lectures. You can always view them on our Facebook pages, the Pulse page, and as well as the Rex Bookstore page. So once again, thank you everyone for attending today's discussion. Thank you to Pulse and to Rex Bookstore. And see you again on our next free week discussion. Bye.